All rise. The court hearing between Blake Lively and Justin Baldoni has started. The first time a judge is there to answer a lot of our pressing questions. Let's get to what happened. Welcome to Popcorn Planet. I am Andy Signore here with the amazing It's Kim. We love It's Kim, and we're here. We're watching live tweets from Inner City Press. Thank you, Inner City Press. I'll make sure to be tipping after this. Make sure you do too. He's out there doing this. We're always looking for people in New York who might want to attend these hearings to give us their insights so they can report for us. I'll throw you a couple bucks. If you know how to do it, you're a court reporter out in New York, hit me up on Instagram or Popcorn Planet Gmail. Let us know. We got the Diddy hearing. We got this hearing. A lot of stuff happening. I'd love to try to get some more people helping us out, getting these courts and make sure we get updated. But here's what we have from Inner City Press. Kim, let's go through. I'm going to read these. Let's sort of add our commentary as to what happened. Overall, I got to say, I'm surprised. Not a lot really happened. The judge did seem to be annoyed with Justin's team in the amount of stuff they were putting out there, but didn't really come forward and tell them, that they have to remove it or gag orders. None of that happened, but clearly was like, all right, enough, no more. It's time to stop. Let's start focusing on the trial. And I can't disagree with them. At this point, I do think Justin's done a very good job through his team of getting enough out there for us to say, okay, this case is not what it looks like. Let's see what happens in the court. And I hope he really sees this through. But here we go. All right. So the first thing that happened was he talked about consolidating the cases. So there are 3 cases currently happening. There's the Blake Lively versus Justin, and then there's the Justin versus the New York Times and Justin versus Blake Lively. So there was a Justin versus New York Times that happened in California that we're told through these checks that Friedman is going to dismiss and focus solely on the New York case against New York Times and Blake Lively. So they've now been consolidated into sort of all the same case. And it's all now happening in New York. There will not be one in California, which is a bummer because, Kim, if it was in California, we might have actually gotten that one televised. Sadly, this one we will not. So I'll need to manage the case, discovery, required information, yada, yada, yada. Lively's lawyer from Wilkes Barre. Our plan on docket 48 is no longer feasible. Counsel for Wayfarer did not tell us they plan to file an amended complaint, including a 168-page compendium full of text messages. There is authority to deconsolidate cases. Basically frustrating, like we came ready, and then, of course, over the weekend, you guys filed 168 pages of things that completely threw this whole thing into chaos. Lively's lawyer, the Times, may have its own views about the consolidating all these cases now with more information coming out. We'd like to confer, given that Wayfarer parties added a new defendant. We have contemplated amending our own complaint. We have 2 weeks to do it. We think we can still make the trial date. So basically saying they threw a wrench at us, but we're going to try our best, Judge, to get this all sorted and hopefully not cause delays. We may still amend our complaint. Blake Lively's side all seems okay, fair. Lyman, the judge, you suggesting that you'll add new parties by next Friday? How quickly would you serve them? Lively's lawyer will ask them to accept service. If they say no, we'll immediately start trying to serve them. There's one set of lawyers on the other side. Lively's lawyers, there will be numerous depositions, including on the false light claims. Discovery will involve issues typical in SH cases and communications by defendants and their agents and the media, including people who may have been paid. Lively's lawyers, this case involves a number of high-profile individuals, including third parties. We intend to seek a protective order. There has been a significant amount of leaked material into the media. We want to list all the parties from the beginning. So again, trying to protect some of the celebrity information, which is odd to me. It's all public use. It should be, but some of this was private correspondence and some of these celebrities may not have been involved. And we don't want another Diddy situation, right, Kim? Where anybody who is caught speaking up in a text between these people is suddenly now thought to how to freak off and cursed off Justin. I think that's what they're actually trying to avoid here. And I can't say I don't do you, Kim, that doesn't seem like a problem to me. Does it seem to you?
No, I don't think that it's an issue. Ultimately, I think people that are not directly involved in this have a right to defend themselves. And I think it will be interesting to see how the judge moves forward when it comes to high profile individuals. I think it is a bit of a slippery slope, but we'll see how it's handled.
Yeah. And so as we continue reading these, Judge Lyman, you each know of the third parties that are going to have interests who are going to have interests whose interests you are going to want to protect. You have a number of high profile people. Lively's lawyer, we'll submit a protective order by March 11th. So he's pushed back like, well, yeah, what does that mean? Whose interests are we protecting? Why? We'll know more by March 11th. What about Jones? Lively's lawyers, we'll see if that case gets consolidated for purposes of discovery. Baldoni's lawyer, We intend to dismiss the California case and go forward here. That's the one against the New York Times. Judge Lyman, what have you added to the amended complaint? Friedman, promissory fraud. Baldoni's lawyer, Friedman, I don't know who the other parties are they aim to add, but if they will need separate counsel, but discovery will be the same. Judge Lyman, how far along was the California case? Not far at all. It doesn't make sense to be on two coasts. Baldoni's lawyer, Friedman, we're asking to hold Miss Lively's deposition as soon as possible. We don't need any documents to do that. The harms have been ongoing since the New York Times article came out. Losses to Wayfair and Melissa Nathan losing clients. Intercity Press back saying, Baldoni's lawyer, Friedman, we need to move forward to still have livelihoods. I can work as early as today to know if the new parties can be represented by us. We don't want delay. Judge Lyman, you'll get document requests. I'm not going to allow depositions now. I don't want the depositions to have been done twice. So no depositions until we know who all the parties are. So delaying them, but fair excuse. Kim and I were both watching it. It seems like a fair thing. Let's figure out everybody's involved. And then you're going to go do your depositions so that way you don't go back and request it again.
Yeah.
The lawyer for Leslie Sloan and Vision PR, we're going to have to move to dismiss the false light and civil extortion claims. This is really a case about their crisis management team saying they are going to bury people. They are just finger pointing at us. We want to move to dismiss. Are you moving for a stay of discovery? We shouldn't be subject to it. My client's female-run company shouldn't be subject to this. That was the first real moment. Kim, what do you think? As a female, do you think female-run companies should be exempt from, being deposed and going to trial? What are your thoughts?
I feel like if this is the situation where we're saying that a woman-run company should be exempt from this, then that would mean that Tag PR would also be exempt from this too, which I don't think is going to be the case. It's an interesting concept, but I don't think it's going to hold up. Not that defense.
Yeah, it was a very weird take. I got it. I can't lie. That was the biggest joke in the whole thing. A delay makes sense. What about interrogations? They are standard. We believe you'll dismiss us as a defendant. Let me hear from the parties in Jones versus Abel. Delay makes sense for Jones, Abel's, Friedman. My client's company is also woman-owned. And in New York, in NYS court in this case, there was a discovery before we removed the case here in federal court. We want to strike 168 pages. I assume this new timeline.
Yes.
What was the purpose of that attachment, Mr. Friedman? So now the judge is a little testy. Why'd you do that? To show the basis of our claims. It's going to make discovery easier. We're putting it all out there. Judge, that's what the federal rules are designed to prevent. Lively's lawyer, look at this. There are images of text messages, then a narrative from a speaker who we don't know who it is. They have to be in the paragraphs of the complaint. So we can move under Rule 11. We are prepared to do that now. Lively's lawyer, we want Your Honor to know that they have put it all on a website. We think it's improper. Here it is. Now more press to the website, ironically. The Lively deposition will not be taken for now, but Miss Lively does not get to choose who deposes her. No, says the judge. We'd be fine if they deposed without documents, but there are other parties. They're still trying to make complaints here. And again, this confirms that Lively did make that request and the judge had to say, no, Miss Blake Lively, you don't get to pick who deposes you. That's another big takeaway from this. But there are other parties. Submit a protective order, he said. Friedman goes, only documents that can be accessed by anyone online are on that website, which is a good argument, right, Kim?
Yep.
It's not like they put something out there that wasn't. I mean, granted, some of those texts and things in there could be debated, but they were all legal documents. Judge, I'm going to hear from Mr. Golub about pretrial publicity in a moment. Shout out to Intercity Press. I'll adopt the case management plan with the following changes. Interrogatories are due March 14th in Jones v. Abel. I'll adopt the plan, except that I'm not adopting the date for the pre-joint trial order nor deadline for summary judgment. Judge, do you wish to be heard on pretrial publicity? Lively's lawyer, the issue is straightforward. The conduct of Mr. Friedman has violated New York rules of professional conduct. They prohibit extrajudicial statements like this. Lively's lawyer, Mr. Friedman has made statements to the media across the country. We've provided a list. He appeared on the show as of his former client, Miss Megyn Kelly. We put him on notice on December 23rd. Then he is liable and now a fact witness. Lively's lawyer, their response is, in essence, that Miss Lively started it. But the rules, it's a very good argument because she did. But the rules apply to statements of lawyers and they haven't pointed to any. You can't just speak on and on in response. We have not requested a gag order. I mean, they did. Lively's lawyer, We cite the General Motors case of 2015 about lawyers' communication adopting the NYS rules for federal case. Why isn't there harm addressed by the ethical authorities in New York? Mr. Friedman is he can't practice in New York, which is odd. That's what pro hoc vice means. Their statements are being amplified on social media, says Blake's lawyer. It's very hard to unring the bell. Judge Lyman, give me one or two examples. On January 7th, Mr. Friedman said we were releasing the statements to show an attempt to take over the movie. Our client's show, on his client's show, Friedman's client, Megyn Kelly, he said evidence is being planted. He said Blake Lively was no victim. She used allegations of SH to try to become the director of the movie. Judge, here's a good clapback. Isn't that all in his complaint? Yes, because it happened.
Yeah.
Wait, or I guess as Blake would say.
That's because this never happened.
You're not supposed to, got some Spyro in there. Lively's lawyer, you're not supposed to launch attacks on the character of your adversary. Kim, what do you think of that? Lively's lawyer having the audacity to say, you're not allowed to launch attacks on the character of your adversary. What do you think about that?
I think that's incredibly interesting considering what we've heard from Blake's side, from the Lively side, in court filings, as well as the New York Times piece. It's a bit rich. Not here for it. Just me.
Sorry, hold on one second.
No
there we
worries.
go. Baldoni's lawyer, Friedman, for months before any filing was made in this case, New York Times giving 12 hours notice to put an article that completely devastated. Judge Lyman, you don't have enough evidence that Mr. Kola was behind that. Friedman, they used the press. January 2nd, they said nothing changes anything about Miss Lively's claim. We encourage people to read her complaint. You could have said that, review our pleadings, but you went further. They said SH is illegal. My client suffered hundreds of millions of dollars in damages. We're willing to stipulate to local rules. I will adapt to the rule with some reluctance. Still, I don't want satellite litigation about the statements of the lawyers. If it turns out this ends in being litigated in the press, I may accelerate the date of the trial. Unless the case is settled, a jury will speak. Damage is done before a jury speaks. I get it. Adjourned. So Kim, look, not a lot that we got out of this, but it seems like the judge is annoyed, but agreeing, let's move forward and stop this chaos. It's time to start taking this serious is the vibe I get. What do you think?
Yeah, I agree. I think it's kind of one of these situations where if this continues for over a year, I think it's going to be pretty brutal. Just mudslinging in the media, I don't think it's a good look. And this process is a process for a reason. Discovery, depositions, all that stuff needs to happen before it goes to a jury. And if they intend to go before a jury, all of these pieces of information need to be considered. And at that point, we'll have a full picture and a judgment can be made, and it will be made properly based upon the system that's built to do so. So I think it will be interesting to see how things go from here, but I think everybody's kind of been put on notice to behave. That was kind of the vibe I got.
Well, there we go. That's the adjustment. Appreciate you guys watching. We got so much more coming. In fact, we're going to be live later today. I hate to cut this stream, but Piers Morgan just texted me and wants me to go live, Kim, to go respond to this case. I can't miss that opportunity. So I got to shut us down. Kim, you want to go live quick? I can't even do it. I got to shut us down. I got to just go. We're going to be live again later to go through more of this. So stay tuned. A lot more is coming on this case. But after this, I'm a little worried that they may not give us as much information, but that might be a good thing. Stay tuned. Make sure if you haven't already, hit that subscribe button, hit that bell for all alerts, smash that like button and all that. We got so much more coming for you, and stay tuned. I'm going to jump over on Pierce. See you guys soon. Bye!